Good afternoon, good morning, good evening for everyone. It's really a warm welcome for everyone who is joining this webinar, whether those who are panelists who are sent video recordings and those who are participating as an audience. My name is Eszter Kismődi. I'm the Chief Executive of Sexual and Reproductive Health Matters. I'm warmly welcoming our panelists today, Ellie Miller, Michelle Kretsch, Katrina Karkazis. Also, we will give introductions to our colleagues who are joining through video recording. And I wish you a great event, and handing over to Ellie Miller, who is the co-director of the Global Health Justice Partnership of Yale Law and Public Health Schools, and also member of the SRHM editorial advisory board. Thank you so much, Ellie, for agreeing of co-organizing this event and moderating the event. Over to you, and thank you for all of you being here.
Well, it's my place to thank you for helping us to organize this and to make the point that this is a particularly timely and important event to talk about, on the one hand, an article written by our authors, Professor Katrina Karkazis and legal scholar Michelle Kretsch, called "What Do Oral Contraceptive Pills Have to Do with Human Rights Abuses in Sport?" But well, as I'll explain why this is timely, because these questions of how science comes to law and how rights are protected by different mechanisms, and in particular, how athletes from the Global South are scrutinized, are all at issue in the paper and from the remarks you're about to hear. I'll say a little bit about myself. I'm here because I also joined in some of the work on this issue, working with an international team of legal and health justice advocates to write an amicus brief with the World Medical Association, and we're going to hear from Dr. Ottmar Kloiber from the WMA, supporting Caster Semenya's challenge to the gender regulation of women's sports. And in particular, we had focused on the intersection of ethics and health. I would like to say a little bit more about the context and why this journal article and the publication of this journal article is so critical for all persons concerned, not just with human rights in sport, but with sexual and reproductive health and rights more generally. The timeliness is this. The Grand Chamber of the European Court of Human Rights is holding a public hearing on May 15th on Caster Semenya, the South African champion runner, her ongoing challenge to the rules, the gender regulations that have been adopted by World Athletics and which govern her eligibility to compete, and which barred her from competing because she refused to be coerced into a medical intervention that she did not need or want. These rules, as promulgated by World Athletics, target athletes with differences of sex development, requiring them to those to whom it is applied to lower their naturally occurring testosterone by means of medical interventions in order to compete. So this May 2024 hearing of the Grand Chamber of the European Court of this challenge resulted from a hearing earlier and a decision earlier from the smaller chamber of the European Court, where the government of Switzerland, and this is tricky, this is how we get here is an important fact about why we're in the European Court. The Grand Chamber is hearing the Swiss government's appeal from a decision against them from last year, July of 2023. And in this decision in July of 2023, the 7 judges of this chamber of the European Court ruled in Caster Semenya's favor. They found that the Swiss Federal Tribunal, which at that moment was operating as a court of kind of limited scope of review, that the Swiss Federal Tribunal had failed to protect Semenya's rights when the Swiss court upheld a decision by a different court, a private court, the Court of Arbitration for Sport. So notice the boxes within boxes within boxes that these questions of health and evidence will arise in. The European Court had stated last year that the Swiss government, the Federal Tribunal, had not met its obligations under the European Convention on Human Rights, that it had failed to protect Semenya's rights to non-discrimination, taken together with the right of private life And they also found a violation of the right to an effective remedy, taken together with the right to privacy. The judges ruled, and they stated that the Swiss Federal Tribunal had failed to provide sufficient institutional and procedural safeguards to have her complaints examined effectively, especially considering her complaints concerned substantiated and credible claims of discrimination. So the voices we're going to hear from today, Dr. Carcazes and Dr. Kresh, wrote an article which goes directly to the entry point of how the misrepresentation and apparent misunderstanding of how to consider scientific evidence on the effects and uses of oral contraception matter in the context of these regulations. So the analysis is important of this evidence because the role that oral contraception plays and its potential dangers matter for how a court understands, is the discrimination fair or proportionate or disproportionate? So the analysis that you're going to hear from our authors today is going to be helpful to understand what the appropriate scrutiny of a court should be in regard to what the World Athletics regulations compel athletes to do, because they are looking at the actual evidence of how oral contraceptive pills work and what relationship they have to the obligation, the regulations requirement of testosterone be lowered. So I'm going to let the experts focus on how oral contraceptive pills work, how they entered into evidence in the Court of Arbitration for Sport, why the Court of Arbitration for Sport is even in the business of assessing something that has human rights implications. And I will turn first to Michelle Kresh to talk about the legal frameworks that make the evidence around the scientific evidence around oral contraception so important. So could we turn to you first, Dr. Kresh?
Yes, thank you, Ali. So I'm going to start big picture. The paper we're using here as a jumping off point today came about in light of the range of fairness and justice concerns that sex testing regulations bring up. Katrina has been particularly interested in the concerns related to the use and misuse of science, and I have been particularly interested in the concerns related to the disregard for human rights law. And we came to realize that these phenomena are happening in tandem, that the way the courts and the public speak about the science of sex testing have in many ways obscured from view considerations of human rights as well as medical ethics. So sex testing regulations, of course, implicate a range of human rights protected in international and national law, rights related to equality, to health, bodily autonomy, psychological integrity, and so on. And significantly, physicians are recruited into these potential violations of human rights because sport governing bodies rely on physicians to bring athletes into compliance with the testosterone suppression requirement of sex testing regulations. This evidently interferes in physicians' ability to uphold their own ethical obligations, which relate to respect for autonomy, non-discrimination, and so on. So I and others have emphasized that these concerns, these legal and professional standards, were largely passed over by the Court of Arbitration for Sport when it considered Caster Semenya's challenge to World Athletics regulations in particular. And so we now want to draw attention to the fact that central to this sidestepping of human rights and medical ethics by the Court of Arbitration for Sport was its fact-finding and fact-making about oral contraceptive pills. So in terms of the legal decision-making process, this fact-making that we're referring to took place when the Court of Arbitration for Sport, after finding that World Athletics female eligibility regulations were discriminatory on their face, turned to consider whether this discrimination could be justified. So how does the court determine if the regulations are justified in this way? It asks whether the regulations are a necessary, reasonable, and proportionate way of achieving World Athletics' purported objective, which is to uphold the so-called integrity of female athletics and the protected class of female athletes. Now, the necessity of the regulations turned largely on the science of testosterone, an issue that has received much attention and criticism. But the reasonableness and the proportionality of the regulations turned significantly on the science of oral contraceptive pills. And this part has not, until now, been really picked up in the public discourse. So we're drawing attention here to how faulty assumptions about the science of oral contraceptive pills was used to deem these regulations reasonable and proportionate. So let me put it this way. If the effectiveness of oral contraceptive pills as a means of complying with sex testing regulations is in doubt, and it is, then the regulations cannot be said to be reasonable. And likewise, if the harms of oral contraceptive pills when used for this particular purpose are not properly accounted for, and they have not been, then the regulations cannot be said to be proportionate. So Katrina is going to discuss each of these two mistaken assumptions in detail. So I just want to first emphasize that human rights standards and principles of medical ethics were notably absent from the Court of Arbitration for Sport's analysis of the reasonableness and the proportionality of World Athletics regulations. The panel, for example, explicitly found that an amicus submission from UN human rights experts, as well as expert reports from lawyers in various domestic jurisdictions, all of which said, the regulations contravene human rights norms and standards. The panel said these are basically irrelevant to its decision-making. The panel also did not engage with the various arguments that were put forth based on standards of medical ethics and bioethics. Instead, the panel simply said that whether the regulations violate human rights law will, and I quote here, ultimately be a matter for the courts of various jurisdictions to determine. So there's really two really important things to flag here. First, athletes are required by World Athletics Constitution to bring any disputes they have about the regulations and otherwise to the Court of Arbitration for Sport rather than to other regular courts. So we can't simply say other courts will take care of the human rights stuff. There is no clear path to challenge before a domestic court. Arbitration before the Court of Arbitration for Sport is mandatory. And the second thing is that even if a case does ascend sort of by appeal to the Swiss federal court and then to the European Court of Human Rights, as in Semenia's case, the fact finding occurs first and foremost at the level of the Court of Arbitration for Sport. So it really matters how the Court of Arbitration for Sport approaches scientific evidence. And so, we're concerned about the way that the Court of Arbitration for Sport has dealt with this, with science or the lack of science related to oral contraceptive pills. In Semenia's case, the panel essentially assumed that oral contraceptive pills were an effective and not particularly harmful way of complying with the regulations, while, and this is really important, sort of losing sight of the particular context of oral contraceptive use when it comes to sex testing regulations. So this is an unstudied, off-label use, not for any medical benefit, and with a strong element of coercion. Because of this, the Court of Arbitration for Sport panel was tentative in upholding the regulations. It noted that, it had to make a decision based on the admittedly limited evidence before it, but it ultimately decided to leave it to World Athletics to make sure the regulations were, and I'm quoting again here, workable in practice. So this is essentially a sidestepping of the standards of human rights and medical ethics. It's therefore really not tenable for World Athletics, to claim that its regulations comply with human rights when the Court of Arbitration for Sport avoided these standards altogether. It's also not tenable to simply rely on physicians to implement World Athletics regulations because, as I mentioned, doing so will often be in contradiction with their ethical obligations towards patients. So to conclude, human rights and medical ethics, which really are two sides of the same coin here, have been obscured as courts have generated and then left unquestioned various facts about oral contraceptive pills. Facts that they think they need to be able to come to a decision. So the legal process is sort of demanding evidence that might not exist, and instead of potentially recognizing that, sort of scientific knowledge is being generated in what ways that we're concerned about. In short, the finding that the regulations were reasonable and proportionate was only possible based on either unverified or actually demonstrably false facts about oral contraceptive pills. But even more than that, and this we really want to emphasize, reliance on these generated facts about the effectiveness and harmlessness of oral contraceptive pills has sort of distracted from the sort of central harm that's associated with these regulations, that it's a coerced medical, but not medically beneficial bodily intervention. So I'll pause there before we get into the specific mistaken assumptions about oral contraceptive pills outlined in the paper.
Thank you so much, Michelle. So, and before we turn to Katrina, I want to remind people that as the webinar progresses, we'll hear first from Dr. Karkazis and then from actually a representative. We have a videotape, as Esther mentioned at the outset, of someone from the World Medical Association to stress the particular problematics of the ethical role of physicians, the unethical role of physicians in these regulations. So we will come back to that point that Michelle made, but we're going to turn next to Dr. Katrina Karkazis, who is professor of sexuality, women, and gender studies at Amherst College and a senior research fellow at the Global Health Justice Partnership at Yale University. I neglected to even give Michelle Kresh a place where she sits. She is currently a Bigelow Fellow in Law at the University of Chicago Law School and a JSD graduate of NYU. So thank you, Michelle, and next to you, Katrina.
Fantastic. Thank you all so much for organizing this. Thank you to all of the attendees for joining us. We're really grateful and we think it's a really important issue, so we appreciate your time. Before I talk about the two mistaken assumptions, I want to say a couple of overarching comments based on about 10 to 12 years of work in this area and how people tend to think about this issue. When these sex testing regulations were first passed and put into place, there was an argument made about the role of testosterone and its relationship to athleticism. These regulations were initially passed both by World Athletics and the International Olympic Committee in advance of any science on this issue being presented. This is really important. Because we're seeing something similar happen in what we're talking about now. Second point I want to make is that there is a tendency towards scientism in these debates. And what I mean by that is a tendency to privilege medical scientific knowledge above all other ways of knowing, all other ways of arguing about whether or not these regulations should be in place, whether they're fair, whether they violate human rights. It is not the case that this is the only way by which we might argue, think about, contest these regulations, but it has become the primary lens. And so for that reason, people turn to scientific evidence and assume that what it says dictates what we should do. But I think we need to separate those two questions. Finally, two more points. Scholar Sheila Jasanoff, whom we quote in the paper, has argued that the scientific knowledge that the law needs for its purposes is often not available until the legal process itself creates the incentives to create it. So that's precisely what happened with the evidence on testosterone and athleticism. It happened after there had been a court case in which World Athletics lost. And they were allowed more time to create this particular evidence. But I want to caution against a concern or a conclusion that I don't want you to take from this, which is that we need more evidence to be able to decide this particular issue. So that the idea that we now need to begin studies on oral contraceptives and how they affect women who are working in compliance with regulations is not what I want you to take away from this. And I think it's a really easy conclusion to come to. So we'll talk a little bit more about why that is. But Michelle's already talked about this. The reason is that this is a coerced medical intervention that does harm to the women who are so regulated. No amount of evidence removes that fact. So let me get into the assumptions that were important in this case, and from my own perspective are why sex testing regulations are still in force right now. So the first mistaken assumption is that oral contraceptives are an effective and indeed the only method by which women will comply with these regulations. It's important to know that there are multiple ways that someone might lower their testosterone to be in compliance. But World Athletics said to the CAS panel, and the CAS panel accepted this, that this would be the exclusive method by which this would be done. This claim that only oral contraceptive pills would be used was based on exceedingly limited evidence, and it ignored the evidence presented in the case that was both to the contrary and also the gaps in evidence. So I want to underscore this. The only evidence that oral contraceptives could lower testosterone below the specified threshold came from a single expert from World Athletics. This single expert was also a key architect of these regulations. In other words, this expert had been involved in creating these regulations over the time that they had been implemented, which was 2011. Her evidence relied on clinical experience with one patient whom she claimed she had significantly reduced that woman's testosterone level through the use of oral contraceptives alone. One expert, one patient. There are no studies on how you lower testosterone with oral contraceptives. These don't exist because this is an unorthodox use of these particular pills. There are no guidelines and there are no protocols because, again, these are not being used for the purpose of contraception, for which there's vastly more evidence. It is being used for regulatory compliance and quite simply to lower a woman's testosterone level. This is not how these pills are used, have ever really been used. However, there was consistent agreement among the experts at CAS that these were not, oral contraceptive pills were not as efficient in inhibiting testosterone as other methods. Moreover, there was evidence to the contrary that came from Semenya and also her physicians about the difficulties of keeping a stable level of testosterone using oral contraceptive pills. So to be clear, the idea that these would be effective, most of that evidence came from one doctor's experience with one patient, and to the contrary, there are no studies, no guidelines, no protocols around how these might be used to lower testosterone, and most especially around dosage and efficacy in achieving this goal of quite simply lowering testosterone versus achieving contraception. The other argument is that this would be the only method used. We didn't have an opportunity to include some of this research in the paper, but this argument is one that was proffered by World Athletics at a very specific moment when a paper had been published around 4 women who had undergone the removal of their gonads and also the removal of their clitorises under the compliance with these regulations. We'll hear from one of these women later, Annette Negessa, but this was really became an incredibly publicized paper that underwent a lot of criticism, both because the clitoral reduction surgery had nothing to do with the regulations, but because this is an irreversible surgery that can also sterilize women and requires lifelong hormonal supplementation. So when this case, what happened to these 4 women became public, the rhetoric from World Athletics shifted dramatically, and it shifted dramatically to the idea of the exclusive use of oral contraceptives. CAS acknowledged that the other methods were likely to have greater side effects. The expert witnesses acknowledged this. And directly after the end of Caster Semenya's case, World Athletics went back and confirmed that these other methods might be used. The other methods meaning stronger pharmacological drugs, as well as surgical removal of the gonads to lower testosterone. But these other methods were not considered in Cass's analysis of the harms. So mistaken assumption number 2 is that oral contraceptive pills are not harmful because many women use them for contraception. For me, this was the impetus for this article, because I felt like many people accepted this argument without more critical interrogation of it. So the gravity of the Cass panel's unexamined assumption that oral contraceptive pills would be an effective and an exclusive method of complying with the regulations was compounded when it came to assessing their harms. There was disregard of the harms of the other methods, and in fact, they weren't even considered. And there was also minimization of the harms of oral contraceptive pills for testosterone suppression. Once again, regarding the harms of oral contraceptive pills, they relied on the testimony of one expert for World Athletics, who claimed that the side effects would be no different than, quote, those experienced by the many thousands, if not millions, quote, of women taking oral contraceptive pills for contraception. On top of this, there was an assumption that the supposedly minimal side effects from oral contraceptives when used for contraception would be the same as those used for testosterone suppression. But this is remarkable because, as we've already explained, there are no guidelines, there are no protocols, and there are no studies regarding this. So there was no expert witness that was certain whether higher doses would be needed to achieve the goal here, which was testosterone suppression, and whether those higher doses would increase the risk or intensity of the side effects. Semenya is the only person who's undergone this intervention for this person who was present at the Cass hearing, and she listed a vast range of side effects. But in this case, her testimony was secondary to that of the one World Athletics witness. So the panel proceeded on the unverified assumption that these effects would not worsen with the new lower cap on testosterone mandated by World Athletics. So from the time these regulations were implemented until the current moment, this threshold for testosterone has been lowered multiple times, and indeed has been lowered once again since this case was heard. The panel assumed, as one might in many medical instances, that clinicians would, quote, individualize treatment to minimize side effects. And this is a sensible approach when there's a particular medical goal or benefit, like contraception. But this is not a feasible approach when the goal is to lower testosterone below a specific threshold, because in some cases, the interventions needed in order to do that will actually increase side effects and problems. So altogether, there's a minimization and false equivalence of the harms associated with oral contraceptive pills, and this distracted from the greatest miscontextualization of all in Cass's reasoning, which is that unlike those who choose to take oral contraceptive pills for some medical benefit, athletes who undergo these interventions based on the threat of losing their career do so absent and even despite considerations of health and well-being. This is a difference that the Cass panel failed to account for and that completely undermined its assessments of the harms caused by these regulations. So to finish quickly, to put it simply, even if using oral contraceptive pills to comply with the regulations carried the exact same health risks that one might have when using them for contraception, there is absolutely no health benefit against which to balance these risks when using them for regulatory compliance. Oral contraceptive pills are not benign, no matter how many millions of women use them, but their use may be considered beneficial to a patient and to a physician in light of the desired health benefit or goal. but choice is foundational to these decisions and the weighing of these risks and benefits. When the goal is simply and only regulatory compliance, as it is for these women, there is no free choice, no medical benefit. There are only harms, and foremost among these is the coerced manipulation of one's body, which is a significant harm in and of itself. And this is what the CAS panel largely ignored, as well as the Swiss federal court afterwards. So whereas oral contraceptive pills are typically used to enhance autonomy, the opposite is true in the context of sex testing in sport. Instead of enabling choice and control, this particular implementation severely limits both. And for that, I turn it back to Ali.
Thank you, Katrina. I think those are, the structure of the arguments between the way the legal frame is set up that Michelle has presented us with, and then the way the evidence matches or mismatch of the legal frame, and then the highlight here, the ethics. So I'm highlighting here the question of ethics because the next person we're going to hear from by videotape is Dr. Ottmar Kloiber, who is from the World Medical Association. And the World Medical Association has consistently opposed the participation of doctors in the application of these regulations precisely for the reasons that have been laid out. That it is an unethical practice. It is not the practice of medicine. It is the practice of coercing a person into a set of medical intervention. So we have a videotape of Dr. Kloiber, and I think that's what we'll see up next.
My name is Ottmar Kloiber. I'm the Secretary General of the World Medical Association. Bringing together 140 national medical associations, we are the platform for developing the rules of practice in physician deontology. I'm proud to say that we physicians have a global understanding of our ethical rules. At the heart of our practice, we are steadfast in our commitment to respect a person's dignity and reject any treatment based on coercion. The exceptions to this rule are not lightly taken and are extremely narrow, confined to severe medical conditions that necessitate treatment, such as in psychiatry, or measures ordered by law. We aim to guarantee the highest level of ethical practice, and we certainly do not make exceptions to meet the expectations of sporting rules. Our fundamental ethical principle is to ensure respect for our patient's free will, which is all the more important when the treatment has no medical indication. It is therefore completely irrelevant whether such treatment is deemed medically safe or often used. Our Declaration on Principles of Healthcare in Sports Medicine, which was adopted over 40 years ago, contains an explicit statement, and I quote, "The sports medicine physician should be aware that methods, drugs, or intervention which artificially modify blood constituents, biochemistry, genome sequence, gene expression, or hormone levels, and do not benefit patients violate the basic principles of the WMA's Declaration of Geneva, which states, 'The health and well-being of my patient will be my first consideration.' Our rules prohibit manipulations like doping, and they also apply to the World Athletics eligibility rules. Those rules condition the participation in competitions by female athletes with differences in sexual development on a medical intervention to reduce their natural level of testosterone in the blood. Through these coercive interventions, these rules openly deny women's rights, their dignity, physical integrity, and autonomy. They deny their right to control their own bodies, including the right to make their own decisions about health and contraception. In addition, the World Athletics rules ask physicians to act deliberately in breach of their ethical duties to athletes, hampering the trustworthy patient relationship. The Declaration of Cordoba on patient-physician relationship defines it as, I quote, "the fundamental core of any medical action centered on a person. that must be protected at any time from interference from governments, other agents, and institutional administrations in the practice of medicine, off quote. Our ethical rules are not subject to the business interest of any group. They are not mere options to be selected according to the interests at stake. I thank you for your attention.
I think the combination, this understanding that ethical rules for doctors are part of a system to protect the human rights of athletes is a critically important takeaway from what we've just heard from Dr. Kloiber. Having said that, I'm honored to present now a videotape from both an advocate for athletes and an athlete herself who has been subject to these rules. We are going to hear next in a videotape from Dr. Payoshni Mitra, who is the Executive Director of Human in Sports and an athlete's rights advocate. And she will be joined by Annette Negesa, who is one of the athletes, as Katrina mentioned, who was subject to a different form of intervention as part of the regulatory obligation of these rules. And I want to emphasize again what Katrina mentioned. Not only did the European Court not find the regulations to be invalid themselves, so the regulations are still in force, and they have been amended to make them broader in scope and more rigorous in terms of their operation on levels of testosterone. So these are not abstract problems. These are ongoing. World Athletics doubled down is the other way to understand what has happened with the regulations. And you'll be hearing now from Dr. Mitra and from Annette Negesa. Thank you.
Thank you for giving us the opportunity to speak. It's really special. We wish that we were able to be there with Katrina and Michelle and Ali, but we had to be somewhere else. So please meet my dear friend Annette Negesa, former Ugandan athlete, and I am Payoshni Mitra. We are, we would want to discuss the harm caused by the DSG regulations of World Athletics, its previous iterations as well. I'm sure there will be a detailed discussion there from our side. I have worked with several athletes closely, with 28 athletes to be precise. And I have constantly seen how these regulations have impacted real lives across the world, across Africa, across Asia. I haven't done so much work elsewhere. And I think, Annette, if you can talk about, at the time when you were investigated, it was the hyperandrogenism regulations of World Athletics, a previous iteration of what we see now. And it required athletes with high level of testosterone to reduce their levels to 10 nanomoles, which is now actually reduced to 2.5 nanomoles. And at that time, the options that were given to you were?
Yeah, either I go and run as a man in the main category, or I run as a female before going for medication.
Only if you go for medication?
Yes.
But medical steps, you don't mean what did they say that you needed to do?
For medical steps, they told me either I go for surgery, as what they call it, simple surgery, or they use the injection like to pull up to reduce the level of testosterone.
And you opted for?
And I opted for the injection to do like the reduction of the testosterone.
Did you really want to do it at that point?
Really, at that point, I didn't have enough information about it, and they squeezed me, like they gave me no option. Yeah, for that, because like a sports, I can say sports is something which is really I love so much. Yeah. So it was something which gives me pleasure and makes me happy. And like as I said, they gave me no option. So they pushed me that.
And from wanting to run for Uganda, doing really well, to this whole episode around 2011 and 2012 that happens, which changes your life forever?
Yeah, seriously, that program changed my life forever. My life has already changed since everything happened to me. My life has already changed. I came up, I get some challenges, and whereby I'm still fighting with most of the challenges,
Including health issues,
including health issues,
severe health issues.
severe health issues, and also like depression. That's the thing. End of the day, it really brought too much impact to my life, both physical and mentally. Yeah,
The trauma of what happened.
the trauma of what happened, whereby they knew really that this is what's gonna happen. Yeah, so it was something new, which even I would never thought of that it would be happening alongside my future. Yeah.
And you know, this paper that Katrina and Michelle they have written and they are going to discuss in this particular event,
Yeah.
it talks about the contraceptive pill, which is often looked at not as severe, obviously, as doing life-changing surgery, but there are harmful effects of any form of hormone therapy, which your body doesn't really need, but you're doing it just because you want to compete in sport, right?
Yeah, because you want to compete, you just like they just doesn't give you a space or something to decide on. Yeah.
Yeah. I think we would like to keep it short because we know there will be a very interesting conversation that probably follows this video. We again wish that we were there in person to listen to all of you and learn, and also share our experiences. Annette, I'm sure Annette has often shared their experience, and it would have been really important for Annette as well to be there.
Yeah.
But unfortunately, we couldn't be there. But thank you so much for still making us a part of the event. Thank you.
Thank you very much.
So I first want to thank both Annette and Peyoshini for joining us, but I also understand from some of the chat that people had difficulty hearing. I'll say a bit briefly, and then if Katrina and Michelle can chime in to make sure that people get the full sense of what the conversation between Dr. Mitra and Annette was. Dr. Mitra introduced herself as someone who has been an advocate with athletes, primarily from the Global South, over 28 athletes she mentioned who have been affected by and then have been challenging or attempting to challenge the World Athletics regulation for participating in women's sports. And she encouraged Annette to talk about the ways in which Annette's life as an athlete, her joy as a runner, was part of why she undertook to be subject to a medical intervention, which then changed her life entirely, and which she then identified as a trauma. Both destroyed her joy as a runner and then also traumatized her as a person, because she did not have enough information both about what the intervention was and what the effects would be, and it destroyed her ability also to compete. Is that, Katrina and Michelle, do you want to add in addition to their voices, if I got that correctly?
Just to quickly add something supplemental, I worked with Peyoshini Mitra and Kyle Knight on a report for Human Rights Watch, and as part of that, we created a short documentary with Annette. I'm so sorry that you couldn't hear her important words, but I've linked to that short documentary, which hopefully you can watch afterwards, where the sound is great. And it's about 6 minutes, and you'll also see that there is a longer report attached to this. This is the largest number of women who have undergone sex testing regulations ever to be interviewed. And it's important to know that these are women from the global south. So if you would like more evidence about the harms, you can find them there. That's what I would add. Thank you.
So I think now we have a chance for both to take some of the questions from the chat. But before we do that, I was hoping if either Michelle or Katrina have any additional thoughts, both hearing Dr. Kloiber talk about particularly the strong stance, right, of a medical association saying we cannot participate and be ethical, and yet the remaining, the way in which the regulations also pretend as if that stance has not been made. I think that's quite striking. But other things that come to mind as you hear both Dr. Kloiber's remarks and Annette and Peyoshni's, as well as the general ongoing circumstances of the application of the regulations.
Am I allowed to ask Michelle a question?
Yes, go for it.
Good. I am not trained at all in law, so I try to find people who are the experts, and Michelle's someone I turn to a lot. Michelle, one of the things that I've really struggled with, and perhaps others here listening are as well, I find the process by which women must bring their challenges to be really limited, because it must go through the Court of Arbitration for Sport. And this body is unusual. It's created and funded by the IOC. You made the point earlier that they haven't addressed human rights concerns, although they seem to have claimed at various times that they did. Could you just speak a little bit more about some of the limitations and constraints for how people can bring these challenges, and possibly even why they can't do it in their own country? I think these are questions that people might have who don't understand this circuitous sort of cat's cradle here.
Yeah, it's a really good question, Katrina. So yeah, first of all, as I mentioned, that athletes to participate in international competition are forced to, be bound by all the rules of world athletics. Those rules include that if you have a dispute, you shall not bring it to your domestic court. You shall bring it to the Court of Arbitration for Sport. So athletes are very strongly pushed to that institution. Once they're there, the law that applies is the law that technically is selected by the parties to the dispute. In practice, what that means is the law that it was selected by the sport governing body in its own constitution or statutes. So World Athletics, like most other international sport governing bodies, says the primary rules that govern are our own rules and regulations. So World Athletics does have a prohibition on discrimination in its own constitution. So that is what Castro Semenya and her lawyers sort of drew on to say there is, a prohibition on discrimination in your own rules. So we'll challenge the regulations on that basis. But whether, any other human rights law, domestic or international, applies is open to question. The Court of Arbitration for Sport in this decision decided it was irrelevant, although there are certainly arguments to be made that it should be considered, because, for example, the law where a sport governing body is headquartered, World Athletics is headquartered in Monaco, often technically should apply in supplement to whatever rules are set out in the sport governing body's own documents. But that really did not come into play in the decision in Castro Semenya's case. If in the appeal before the Swiss Federal Court, it's a very, very limited ground of appeal that does not include human rights law per se as a sort of ground of appeal. It's only if the decision by the Court of Arbitration for Sport violates what's called Swiss public policy. This is a very, very narrow concept, and this is what the European Court of Human Rights really focused in on and said, okay, you have, this is the ground of appeal, Swiss public policy, but if you're not going to consider human rights law, European human rights law, in that concept, within that concept, and bring it to bear, then we have a problem. You're violating the European Convention on Human Rights. So that's kind of now where we're stuck. The European Court of Human Rights has said what the Swiss courts did was not enough, but that doesn't immediately change World Athletics regulations. As Ali mentioned, those continue to stand while things get sorted out, and it's a pretty unclear future. But yeah, overall, it's a disjointed process where all the factual findings happen before the Court of Arbitration for Sport, but that court has not really engaged with human rights law, all the way up to the European Court of Human Rights. Finally, they say human rights do matter, but they could, but have not really made new factual or engaged with the facts in a detailed way. So we're sort of stuck in limbo.
So, and if I could add, I think it's actually brings in, I think, one of the questions from the chat about what can be done to challenge the powerful World Athletics body regarding their doubling down on the use of oral contraception. I want to broaden that question, which is how to think about challenging the powerful and essentially, and Michelle has written extensively on this, the way in which sport is the elite sport systems of regulation are insulated from challenge by national courts. Michelle said it, but I think what we should make abundantly clear is that you are between a rock and a hard place as an athlete who is trying to protect your rights or challenge the practice of the World Athletics in regulating sport, which is to say you can go to your country and have your rights protected. They can use their constitution and international human rights treaty rights and protect you. Good. And now you can't compete. So that's the box that we are in, just to make abundantly clear what Michelle has been articulating and to put it in the clearest. And this is part of why the way in which sport has been insulated from human rights review has been the engine that has driven everyone from the Office of the High Commissioner for Human Rights to intervene in this case, to write a report in 2020, which called on both states to protect, but also named what they called the intractable problem, that we must find a solution. We have had interventions on Semenya's case, not just from groups like the Human Rights, the World Medical Association and the amicus we wrote with them from the Global Health Justice Partnership, but the International Commission of Jurists, a number of legal entities trying to think about the problem of athletes being deprived of rights in the system where they work. Essentially, this is also a form of labor. So these are the struggles that we are all in, and which I think this webinar makes those visible, even as we focus on the particular ways in which the reliance on oral contraception has been used by World Athletics to normalize what they're doing, to make it not visible that they are depriving athletes of rights. And I think that's a kind of core kind of claim that we need to sort of keep to the surface. Are there other comments, Katrina and Michelle?
Maybe I'll just say that I guess our goal with this paper in part and with this webinar is to inform public conversations, but also to encourage courts, this limited sort of string of courts that are actually involved, to give a fresh assessment, to correct the mistaken assumptions that we've identified, but that have actually become even more disconnected from reality as World Athletics has revised its regulations or doubled down, as you put it, Ali. So we emphasize in the paper, that the ineffectiveness, the harmfulness of oral contraceptive pills in this context has only been exacerbated by World Athletics' further revision of the regulations, expanding them from the time when the first case was brought to apply to all rather than just some track and field events, significantly reducing the maximum permissible level of testosterone, considerably extending the period of time that this lower level of testosterone must be consistently maintained before the athlete regains their eligibility, and also sort of reinstating the possibility of ineligibility in cases where an athlete's testosterone rises above the mandated level despite their compliance with prescribed interventions. So sort of the the impact is becoming more and more severe. And so these sort of mistaken assumptions that we highlight become all the more significant and problematic.
I might say this with just a little bit more pointed force. Part of what enables this kind of end run around ethics and human rights is the widespread notion among many, not simply the courts themselves, a broader cultural notion among journalists, among otherwise, sort of reasonable people, that oral contraceptives themselves are no big deal, and that they're a key to women's freedom, emancipation, choice, and other things. I don't argue with that. Our claim here is not, by the way, to be very specific, that oral contraceptives are bad, or that's not our claim. Our claim is the way that they're instrumentalizing that broader cultural view towards a very particular end here designed to violate rights. And it's that movement that, frankly, too many people have missed. I've not seen a single journalism article on this. Us academics have missed it. Advocates have missed it. And the reproductive rights community, which is so strong and so important, doesn't know about this. So I just want to express gratitude to Esther for getting this article out in a timely way and in this forum, because one of our hopes, per the earlier comment, I think from Nicole, is that a broader group of people understand the manipulation of certain facts and arguments towards the harm of other women. And this audience is powerful. They seem to see right away the problems with what's going on here, the coercive aspect, because they're so used to the broader history of reproductive coercion among women of color in the US, women in the global South, forced sterilization, clinical trials on oral contraceptives against women unable to consent to those. So this is all part and parcel of that. It's not separate. And one of our goals here is to sort of bridge some of those connections so that this kind of conversation is not happening in a narrowed sports silo where, frankly, they've been able to get away with these arguments. But I think we need to bring in the repro justice advocates who see right through it in order to also speak.
Thank you. That is very helpful. And I think it speaks directly to where I was going to bring us to a close, which is why we are grateful to Sexual and Reproductive Health Matters for creating this space to have this discussion, and precisely to fulfill the ongoing mandate of SRHM, which is both to produce knowledge and to make that knowledge the engine of social change and health justice. And I really want to thank you for seeing the opportunity in this paper and in pulling this together in this timely way to remind ourselves that we cannot affect courts per se, because I want the European Court hearing in May 15th to be independent. But there are things they should know, and there are ways that information can flow. But in addition, to remind ourselves that these athletes continue to be affected. There are ongoing challenges at the court at the Court of Arbitration for Sport. The challenges are real and present. They are ongoing now. So the goal, I think, for many of us is to understand how to be ethical advocates about the ethics and rights of the way in which these regulations function, even as court proceedings happen, but also I think your point, Katrina, about changing the way in which we disperse information, and that too is a goal of SRHM, so that journalists, the media, the broader public that watches sports and is cheering women athletes like never before understands what they are subject to in order to do the thing they love. So perhaps that's a good place to close. Esther, do you have any final words?
I just want to thank you very much, Ellie, Michelle, Katrina, Payoshni, Annette, and Omar for this extremely rich 1 hour and all your work that you are doing in this area. I wanted to just let know the participants, thank you very much for your participation and listening. The webinar recording will be available on the SRHM blog, probably from Wednesday onwards. We also have a podcast channel, and it will be available also in a podcast format. I believe that our partners will be sharing as well both the podcast and the webinar. And please visit the article of Michelle and Katrina on the SRHM Journal website. And we are really looking forward to the deliberation of the European Court of Human Rights from 15th of May onwards. Thank you so much for this discussion, and I wish everyone a very nice day or good night. Thank you so much. Bye-bye.